Now kindly see the first order passed by this court, pursuant to which the report was filed.
Yes. Infighting between the two presidents,
No.
the functioning of the school is being hampered.
It is the only issue involved in the seat petition, ma'am.
Let both be removed.
Madam,
Let third person.
I have no issue, ma'am.
In fact,
I have no issue. I have
that
no issue.
happened. The teacher in charge, Kobita Mahato, has been directed to take charge.
Yes, but no handover
Right.
of charge. Charge has not handed over. My lord, I have a proposal, my lord. Matter can be. I'm the respondent number 8, the president
Who?
of the
Who
management.
has been at the
That
first?
you have a fight with the petitioner.
Yes. No, not
Your
with.
lordship.
No.
No. There is no fight. My lord, I have a proposal. For the interest of the institution, my lord, I have taken a stand. My lord, let the new managing committee be formed. No problem. In the meantime, this managing committee is in function. Various issues have been pending, like pension, salary, all have been withheld. So, my lord, the government has already started taking the process of formation of the managing committee. So, let that managing committee be formed within a reasonable period of time.
Who are you to say?
No, this is a proposal I have received.
No, do not give
Yes.
proposals.
My humble submission is this, my lord. There is
No, thank you for your proposal.
No, my lord.
The ADI has already taken steps in the matter.
Yes, my lord. It is to be completed.
The report says.
The report of
Yes,
the
my lord.
ADI is
Mala, page 7 of my report,
Hmm.
here is specifically stated by the DI to the concerned Deputy Director of School Education. Mala, may I read? I to state that nominated presidents and PIE of the above mentioned school were called for document verification process of 11/3/2025. On the day nominated president, namely Shotava Das and PIE 1 Kunika Ghosh had submitted their paper document, whereas Manjula Ghosh, Mala private respondent hearing, nominated PIE to remain absent on that day. Next, my lord, you were therefore informed.
Please wait.
No, due to health reasons, she did not go to these.
But instead of going into all this, ADI in fact did not address the issue. Issue is the person who has been nominated, whether he should take charge or not.
Well, today, just
No charge has been handed.
just one submission. Today, she is not the teacher in charge anymore. It is the Kobita Mahato today.
Who are you to say
So
this?
that is the report says.
Somebody who is
nobody
not
to say.
there in the office.
The report says.
The additional district inspector of schools has disclosed in the report that Kobita Mahato has been appointed as new
No.
teacher in charge.
Kindly don't accept that, because
It has been
these
done already.
the board in terms of the rules was supposed to function up to 3 years. Now when we have made complaint that I am the senior most candidate teacher, and being a senior most, I have been appointed as teacher in charge. Who are this incumbent, erstwhile president, to remove me from the post?
I did not remove. The managing committee removed. I did not single.
That's
a
another issue.
notification. That's a notification of
It's a
11
vindictive
September
action.
2019, which says it will remain in force. The managing committee.
Hmm.
That removal cannot
It's a
be taken into
notification.
effect.
It cannot say
The
that-
very first time that I have mentioned that.
So the existing teacher in charge, Srimati Papia Chaudhuri,
He has been.
is directed to immediately hand over charge to Srimati Kobita Mahato. Stop. The respondent number 8, that is the private respondent herein, is restrained from interfering in the functioning of this school in any manner whatsoever. Stop.
Managing committee.
Further steps for formation of the managing committee shall be taken by the Additional District Inspector of Schools, Secondary Education, Srirampur Subdivision without any further delay. Yes. Release the matter for further consideration on
It is,
9th March 2026. An updated report by the ADI shall be placed before the court
it
on
is
3rd
my
January.
petition
Without
that
the president.
I am the teacher in charge.
No.
Now, my lord,
Now you go, let someone else come, let fresh
Without the
fresh managing committee
Blood,
be
no,
constituted.
blood, that is another thing. Blood. The issue is, blood, if I am entitled to be discharged as teacher in charge in terms of law, why shall I be removed? And that is not the issue involved in this writ petition. Why the ADI, who was in fact instructing me orally to allow the erstwhile president,
No, now erstwhile President
No,
Dr. Ghosh.
because he is the person who was instructing me to allow the erstwhile president, I did not allow since there was an order of the state. Now, my lord, since I have approached this court, now, my lord, ADI has my lord, now my lord, in his report, my lord, recording that my removal taken by the erstwhile president who did not have jurisdiction.
No, he is not taking it that way.
Yes, yes,
Sir, please wait. There
What
is,
the court's direction was to file a report in regard to the managing committee. It was nothing to do with my post. Now, my lord, on the very first day, I have handed over that immediately after the writ petition was filed, I was served me with a letter that you have been removed. This letter I have handed over on the last occasion. Because of the filing of the writ petition, since I have taken steps in terms of the my lord, direction of the state, now, my lord, does that not has any connection with my removal? If I am entitled to otherwise,
suppose, yes, exactly, just what you submitted, if you are entitled to, you can be elected once again.
but I am already. There was a resolution that I, being the senior most teacher in terms of the law, I am entitled to, and accordingly I have been appointed as teacher in charge. Now, what was the reason behind of my removal? Is there any reason given?
Yes, there are.
What is the reason?
From the report, it appears.
No hearing, nothing. On some fine morning, they have taken a decision that I'll be removed
Hearing is not
for filing this writ petition only.
No,
It
page-
appears that there is non-action from the end of.
Yes, that's the reason I have approached this court.
Deadlock,
Yes,
honorarium not.
but
being
in fact,
paid
my
and everything.
entire writ petition is pleaded with this pleading that because of this non-cooperation of the president, I am not being able to sign the pension paper.
Hmm,
So if that be the reason,
hmm,
I am the person who has approached this court to remove these difficulties,
hmm.
and for that reason, I will be removed.
But for pension, my
Matlab,
signature is
page
not
18 of
required.
my report.
My signature is not
Matlab,
required.
Whatever
HM is the person. My signature is not required for pension.
whatever reasons they have recorded,
But
No,
the
there is-
then president, Matlab, here.
Matlab,
Very,
there
very
is-
frankly, I
your
say,
lordship has recorded in your lordship's order
It cannot
that
be
the
said
present
signature is
president,
required.
the erstwhile president has nothing to do, has
May I say something?
kindly see my
Page
first
18,
paragraph 5 of
first
your
paragraph.
lordship's order, my lord.
There is a resolution of the managing committee, not my decision. Don't argue with me, please.
The person who was influencing, who has harassed me in the office, the erstwhile president,
Dispute these allegations.
and there is a video footage
I also.
that I was harassed,
also
I was
video-
scored, I made complaint to the police.
RIC is not something.
Who is this Kobita Mahato?
She is the new teacher in charge now.
Junior, then
Junior to
yes.
his-
I need to.
And not still the erstwhile president is not running the managing committee. Even if he will be not there, he will be running the institution.
She was
No,
restrained.
no, this is the restraint order that I'm
Yes, yes,
passing.
Same
today,
order, man, is the
That
worship knows that.
no,
But she has taken a decision to remove me and appoint somebody,
Taken a decision. It's a managing committee.
and he will be running the institution behind.
I am not.
And
the
this
person.
ADI, this is the person who was instructing me to allow him.
Undula case.
If you have problem with the ADI, I'll direct the DI
No,
to take steps.
That's not my question of my removal doesn't arise.
All right.
She has
that,
already been removed.
That is that somebody who cannot hold the office has taken a decision to remove me. For that reason, should be.
Is the Is your removal under challenge over here? That is
Nothing.
not under
That
challenge.
it is not under challenge. I told you, Rashim, that on the very first day, that immediately after filing of this petition, this was served on me.
কবে ফাইল হয়েছে 21st January
Let them show a document that it was served on me prior to filing of my writ petition, prior to receive of my writ petition. It was not.
I dispute that. That is correct.
And your lordship has seen that the ADI's report records that for due to non-cooperation I have been removed. That should be some hearing should be held
IC has no right.
prior to my removal. That why you have not done so?
See, from the documents that have been, from the report, there is a resolution of the managing committee which I can
Yes,
see.
that resolution taken by this president.
And there are signatures of others. They
But
were not there.
Yes.
I do not know.
Yes, my lord, they have put their signature. 8
I
persons
do
were
not
there.
know who are there. I am the
Members of the
secretary
man-
of the managing committee.
Submit one thing.
কি
my lord.
I'm the secretary of the
Just submit.
প্রথমটা বলুন তো।
My lord, may I just submit one thing?
And what is the notice of this meeting?
The notice was not accepted by you.
আচ্ছা ঠিক আছে, ওটাকে কাটুন, আপনি পুরোটাই কাটুন। আপনি লিখুন যে the report of the ADI discloses the resolution of the managing committee of the school adopted on 21st of January 2026. The submission of the petitioner is that the private respondent has induced the members of the managing committee to sign on the dotted line. Stuff. The petitioner is the senior most teacher of this school, and a resolution was adopted for engaging her as the teacher in charge. Stuff. She ought not to have been removed under the dictates of the president. Stop paragraph.
Notice was served on me before taking this decision. I am the secretary managing committee.
The resolution was adopted behind the back of the petitioner. Stop. Copy of the resolution was not served upon the petitioner prior to filing of the writ petition.
There is a resolution she was
Stop.
formed.
Next, the from the documents available on record, it appears that by a communicating letter dated 28th of January 2026, that is 1 day after the writ petition was filed, comma, the private respondent intimated the petitioner regarding her dismissal from the duties of teacher in charge. Stop paragraph. The learned advocate for the petitioner contends that the additional district inspector of schools is also pressurizing the petitioner to hand over charge without looking into the issue as to whether the petitioner could have been removed in the manner that has been done. Stop paragraph. The court has already expressed its anxiety with regard to the proper functioning of this school. in view of the infighting between the teachers. Stop.
Not the teachers, but two managing committee,
Answer between the members of the managing committee.
erstwhile president and the president.
The erstwhile president and the
Present
petitioner.
and the present president.
And the present
But the
president.
managing committee is still in force
Acha.
as
next.
per the notification.
To resolve the issue and to maintain normal functioning of the school, the court thinks it fit to direct the district inspector of schools to conduct a hearing of the parties to resolve the hearing of the parties to find out a solution to the problem that has cropped up. Stop. A reasonable opportunity of hearing shall be granted to all the parties. Stop. Prior notice of hearing shall be served upon all concerned. Stop. The decision of the district inspector of schools shall be placed before this court on the adjourned date. Stop. Next. Release the matter for further consideration on 23rd of March 2026. Stop.
May I make one prayer to you.
Who is going to run the show now?
Yes, the managing committee is there, man.
But I am there.
Managing committee is
I'm there.
there. No, he cannot run the show alone.
Because
Managing committee, the salary is withheld, pension is withheld.
But till
The-
today, lad, I am lad doing everything.
She does not have the exquisite right from
Since
the post of
If
PIC.
if the order is,
And my lord, I'm denying
if
the
the decision
allegation.
is nullity,
This is the resolution. She did not appear. She did not appear.
decision is
despite
nullity.
calling.
Therefore,
Despite calling, she did not appear. That is the resolution, managing committee.
a teacher in charge in consultation that lad, DI will do, lad, conduct the
No,
school.
bank operation is not in her hand only.
This is lad, how this erstwhile president is function.
No, everybody is managing committee is supposed to take decision.
It
Not
has nothing to do, but yes,
PIC is
still so many things to do.
Managing committee will take the charge, not you alone.
the district inspector of schools shall take all necessary steps to ensure that the normal functioning of the school is not hampered in any manner whatsoever because of the deadlock that has been created at the moment. I am not mentioning anything. Let the DI take a decision.
Well-
That's only one.
In the
prayer by
meantime,
one
lad,
prayer,
in
just
the
for
meantime, lad, handing over charge will be done, lad.
Which handing over charge?
That erstwhile president to the present president. That will be done.
That means from the respondent number 8 to you.
No,
From
from the respondent number 8 to the present
Master.
nominated president.
But that the new managing committee is to be formed.
That is,
No, not in a single show. The managing
Understood.
committee is to be
that,
formed. by
that
the
should be
DI.
done.
the
Managing committee may be formed in the meantime.
as
No problem with
a
that.
decision has already been taken for handing over charge by the private respondent to the new incumbent Kobita Mahato,
Yes.
the DI shall ensure that the charge handover is positively done within a period of 48 hours from date.
No, Kobita Mahato is the TIC.
Are na?
My lord, just one thing, my lord, the present managing,
Not Kobita Mahato, Shruta Padash, lad.
Shutopadas, please.
Shruta Padash.
Sabadas.
my lord, the present managing committee will function because the pension papers and other functions are withheld.
Next,
23rd.
My lord, I appear for the petitioner.
Appearing on behalf of the school?
My lord, I had appeared, my lord, that this writ petition was preferred against a show cause issued by the school authorities against, my lord, a minor, my lord, for some incident, my lord. That the matter appeared before, my lord, on 6th of February, my lord was pleased to pass an order, my lord, directing me to appear before the, my lord, authorities, my lord. This order, my lord, was carried in appeal. The appeal court has only directed me to take inspection of the material that is against me and file a representation and appear
Friday,
take inspection
Uh-huh.
of the materials that they allege because no copy of allegations was supplied. The court has directed me to take inspection and file my representation before the school authorities on 18th.
Nothing remains in the
No, my lord.
instant
On
petition.
18th, hearing will be done, my lord, and they shall pass an order and place it before the court by 24th. My lord, this is.
Before the tentative date, you expect that-
Kindly see, act, my lord. Kindly takes the order of the appeal court, my lord.
I have given.
Well, page 5, my lord, the operative portion, my lord, at page 4, starts at page 4.
Hmm.
And page 5, my lord, says, my lord, the final decision taken by the school authorities thereafter shall be placed before the learned single judge with a copy to the appellants. List the writ petitioner for further hearing before the learned single judge on 24th
Subject
of.
to the convenience of the court.
Of course, subject to convenience of the court.
ঠিক আছে, please come. The order dated 13th of February 2026 passed by the Honorable Division Bench in mat number, please take down, has been placed before the court. Stop, it appears therefrom that the Honorable Division Bench directed the matter to be posted for further hearing on 24th March 2026. Stop next. In view
Only
thereof,
message for this. If you are also kindly fix it on 24, 27.
in view thereof, list the matter on 24th of March 2026. You make an prayer for adjournment. The
My
court
lord,
will see what can be
the
done.
urgency is, my lord, the final exams, my lord, would begin in May. I'm deep down.
Final long fall. Let me take a decision. Jumping for final exam.
My lord, kindly see the attitude of the school authorities.
No, my attitude is very fair. I am very fair. I allow to
Next.
stick to a midterm.
32.
Very fair attitude.
My lord, order was carried out by the inspector in charge. The other day, my lord, because of the prayers for adjournment, I was not in a position
The
to.
report of the IC, Milord, everything has been done.
My representative
been
was there.
Yes.
Yes.
Yes, now what is the
Now
matter?
the main interim prayers that are sought, but we'll kindly see, my lord, because of the situation in the school, I had sought transfer and I was initially granted such transfer. Those orders are there at pages 146 to 148. Now the fun begins, my lord, from page 149. (148) is the order of transfer of my client and certain other teachers. 149, my lord, is a communication from the Deputy Secretary to the government of West Bengal to.
Initiating disciplinary proceedings.
Yes. On the ground of her alleged failure to discharge her duties.
Hmm.
150, my lord, the Secretary of the Board recalls the transfer order. Kept in abeyance, it's called. Then the next important document is at page 159.
Suspended.
Yes, this is the subject, main matter of challenge here.
Hmm.
On various grounds. My first ground is that the initiation of the proceedings could not have been at the dictate of a third party. It ought to have.
Let them file their opposition.
Lordship.
My lord, yes, they'll certainly file the affidavit.
I am paying for that.
Yes, that naturally is their prayer.
For the purpose of order procedure.
But
I have several documents.
the issue is whether the suspension order is valid or not at the dictate.
That will decide.
But the
I'll interim release.
kindly permits me to place the rule. Three sub clauses of the rule. The 2018 Gazette, my lord.
আমার সঙ্গে শেয়ার কোনটা কোনটা দেখাচ্ছ তুমি
This is the rule now in operation for conducting disciplinary proceedings. My lord will kindly turn to clause 5 at page 5.
Yes.
The board may authorize any officer not below the rank of a sub-inspector to conduct a preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to misconduct of a teacher. From whom? From the committee or the administrator or the head of the institution. If my lord kindly comes to page 159. And compares this with page 159. The initiation is from purported reports of the president, not the committee. And that 12th December 2025, which is the letter of the deputy secretary.
Has the report been forwarded to you?
No. Not the report.
Review of the disciplinary
And in any event, my lord, the contents of the report
letter from the, yes.
would have been irrelevant because of this clause 5.1.
Letter from the deputy secretary.
They're not repaired.
The reports of the president, if there are any of those dates, are not there. And the president, my lord, the president could not have submitted any report to the board on basis of which even a preliminary investigation could have been commenced. Leave aside a formal disciplinary proceeding. My lord, I read on the rules for clause 2, subclause 2. If the preliminary investigation report reveals prima facie a case of misconduct, the board shall issue show cause notice to the concerned teacher or the non-teaching staff against whom the complaint has been made in order to enable him to explain his act or omission in question by such date as may be specified. But here the show cause is issued after the decision to initiate proceedings. That is at page 165. Kindly see page 165. They make up my...
1 minute. Let us go one by one. 5.1 mentions about conducting preliminary investigation upon receipt of a complaint from the committee or the administrator or the head of the institution. This is not there.
This is not there.
Because it is by way of a letter of the president of the school managing committee.
Yes, and the third party, the deputy secretary to the state
And the
government.
letter from the deputy secretary.
In contrast,
Well, and I have answered to this.
let me see. In contrast, my lord looks at pages 48 and 49. I have been, my lord, harping on and approaching and knocking at every door, my lord, ever since my appointment in this school, that there are complaints against the section of teachers and non-teaching staff, pages 48 and 49.
Yes.
These are letters from the disciplinary authority, which is the board, to the DI.
Mhm.
That there are complaints from the head of the institution in respect of so and so. Page 49 is a reminder.
This is of 22.
Yes, these are not acted upon. And that gives them a long rope with which to, my lord, assault me and do anything that they please. Page 49, the board issues a reminder. Even then, nothing was done.
Page 50 and 66.
Page 66,
Page
my lord.
50, yes, that is very interesting. Page 50, page 50. I'm grateful to my learned friend for drawing my lord's attention to this. This is the complaint of a teacher, Shiva Priya Mitro. A complaint of a teacher has no place in clause 5.1. Yet that was acted upon
Well, at page
behind my
66.
back.
Well, kindly come to page 66.
Let me finish. Clause 5.1. Clause 5.1 is the complaint of one teacher who is aspiring to be the teacher in charge. My lord compares this with 5.1. A complaint of a teacher could not have been acted upon. My complaints are, my lord, thrown outside. They do not, my lord, take cognizance of that. And yet, complaint of an individual teacher who is strongly aspiring to be the teacher in charge in my place, that is acted upon. And the DI has the, my lord, authority to say that there's maladministration in the school. If this had been controlled 2 years earlier, my lord, things would not have reached the stage where they have. A non-teaching staff, my lord, he is controlling the show. He's a local. Shahid Ali Mullah, or something like that.
You are the headmistress.
Headmistress. Head of the institution is there in clause 5.1. My lord reads on kindly, my lord, clause 5.3 of that rule.
This
If
is
the
a correct
explanation in reply to the show cause is not satisfactory, the disciplinary authority shall initiate proceedings. So here, this is a predetermined thing. My lord, a set mind at the dictate of a third party and on basis of complaints who could not have lodged a complaint in the first place. And because of this contemplation of proceedings, initiated even before the reply to the show cause is, my lord, considered, the contemplation of suspension. That is there, my lord, at page 159. I have placed that. If the initiation is bad, the suspension is also bad.
All right.
The other arm, my lord, that will, an administrative authority or a quasi-judicial authority, or in fact, my also sitting here, but does not have an inherent power of review. How could they have, my lord, recall those transfer orders?
Well, that is before your lordship and lordship.
How on from what power? No, my lord had given me the, my lord, the liberty to challenge those actions, and here I am. Here I am.
All right.
But authority cannot review just at the dictate of a third party.
All right. Let
No,
me.
my lordship. My lord, what
The
is placed?
suspension order
No,
is
my
by
lord,
the
my lord,
court.
may I? My lord, this is not the correct fact which my lord, my learned friend placed before lordship. My lord, 2022, which my learned friend is showing, the report of DI, your lordship, that page 48, your lordship, he is
Yes.
showing that board has asked the DI to file an inquiry on in 2022. Thereafter, your lordship, the inquiry report as page 50, that is the inquiry report of DI, that is filed in the month of July 2023. Thereafter, your lordship, board
50 is on basis of.
my lord,
Page 50.
page 50 is the inquiry held by the DI, and that
Who made the complaint? Who is the complainant?
at that point of time in 2022, the board received the complaint from the HM against the HM for his misconduct from the school authority. But
School
now,
authority means who?
my lord, now this one is not before your lordship. That is what I'm submitting before your lordship. Now, in that complaint of 2022, my lord, the board has already issued a caution. My lord, kindly come to page 56. That is over. This is a new complaint. My lord, kindly come to page
Who is
56.
the complainant?
At present, on basis of which the inquiry was held, is the president of the school.
Does the
Yes.
president have the
Yes,
power?
yes, your lordship. Because my lord,
Please
number
show.
5, which my learned friend was showing, my lord, kindly see. A board may authorize any person not below the rank of sub-inspector of school to conduct preliminary investigation against any teaching or non-teaching staff upon receive a complaint pertaining to the misconduct of a teacher or non-teaching staff from a committee or the administrator or head of an institution. So here he is the headmaster.
Where is the
The
headmaster?
petitioner is the headmaster.
Who is the
headmistress. The
complainant?
president of the managing committee is the complaint.
Where is the
Head of-
power?
Head of the institution, because
Head of the institution is certainly not the
so, my
president of
lord,
the
when
managing committee.
against the headmaster, who will lodge the complaint? Because managing committee, because headmaster is the ex-official secretary of the managing committee.
Yes.
And then there is one more rule. How board can proceed, my lord? Kindly come to sub-rule 12. Sub-rule 12 of rule 5. Board has a suo motu power, master. The board may suo motu initiate disciplinary proceeding against a teaching or non-teaching staff if there is a reason to believe that any misconduct has been committed by a teaching or non-teaching staff. In all suo motu cases proceedings, a preliminary investigation has to be conducted. So, my lord, board has the
But
power.
then you did not conduct this suo motu. You conducted it on the basis of a complaint of
Of a
some
press-
person.
Yes, we have no. Any complaint we receive from anywhere, because my what it says, board may suo motu initiate disciplinary proceeding against a teaching if reason to believe there is misconduct. How will I have a reason to believe? If there is a complaint before me, a complaint from the president, a complaint from any staff, a complaint from the DI or anyone. So how will I, until and unless a complaint reaches me, how will I know about the misconduct? So the complaint reached me. On basis of the complaint, your lordship, what I have done, I have asked the DI to hold an inquiry. So kindly see the inquiry. Board asks at page 66, board has asked the DI to hold an inquiry. Kindly come to page 66. Well, this is the, to the DI, board has asked to hold an inquiry. Now, your lordship, thereafter, there is an inquiry report filed by DI that is at page 143.
Where is the complaint?
The complaint here
Is stated.
he has not annexed, it is his repetition.
Where have they
Have a
served it?
And then your lordship, I'll because your lordship, in suspending a petitioner, your lordship, there is no provision that the complaint is to be forwarded to him, because suspension is some other. Kindly come to rule 6, suspension.
No, rule 6 is all right.
Yeah. So here, what is the said? Board may, on the following reasons, issue order of suspension against a teacher or non-teaching staff. On this ground, if the teacher or non-teaching staff is under detention, this is not this case. If any alleged misconduct, or if there is a reason to believe that unless the concerned teaching or non-teaching staff is suspended, it may result in tampering or destruction of the evidence, or the concerned teacher or non-teaching staff may cause undue influence in the disciplinary proceeding pending or contemplated. In all cases of suspension, a disciplinary proceeding has to be drawn and conducted as per the required rules. So, my lord, suspension and initiation of disciplinary proceeding are two different things. A disciplinary proceeding is initiated with issuance of charge sheet. So, my lord, this rule 5 says, prior to issuance of charge sheet, we will have to follow this. There will be a investigation. There will be a report to us. We will issue a show cause notice to the incumbent. In this particular case, your lordship, show cause notice has been issued to the petitioner. That is at page 165. And thereafter, my lord, he has replied to the show cause. Now, board, if not satisfied with the show cause, if board decides, board will issue a charge sheet. If it satisfied, board will not issue, no disciplinary proceeding. Two are different things, your lordship. Both are not the same. Here, your lordship, only
I just want to satisfy myself as to whether the disciplinary proceeding or the suspension has been done relying upon proper documents, a regular complaint in accordance with the rules.
Yes. Why?
What I will see at this stage.
Because I have, that is the complaint, my lord. We have asked the DI to hold the inquiry on basis of a complaint made by the president of the school. So, my lord, the president have the power, because to make a complaint, why, your lordship, a complaint misconduct to a teacher and from the committee or administrator or head of an institution.
Resolution been taken by the managing committee?
It cannot be taken, because without the headmaster, who is the ex officio secretary of the managing committee,
Why, there are other members also?
Cannot be done.
Why it cannot be done?
That school can say, but it is not required. It is not required, because even if board receives the complaint, even from the DI, your lordship, board can use its power.
Yes,
have a
from the
suo motu
DI
power.
it is all right.
Yes.
But then from an opposition factor, if it comes, there
What-
must be some
Well,
clash
how-
between the
well-
president and the...
Then, my lord, any
Otherwise-
complaint which reaches the board against any teacher, my lord, then it will be considered
What
as
is
an
the
opposition
complaint
factor.
against the petitioner?
Because lordship, there is something
Do not submit anything. Tell me what is there.
The basic thing is when the meeting is called, prior to that the intimations are to the administrator. But on that time, administrator prior to the starting of the meeting, she locked and key of her room and left from the office. With the all.
Is this the only reason that she locked the room? That is the reason.
Show cause is not on that.
That's why there is no proper resolution.
What is the allegation against her?
So the allegation is there, Lord.
Kindly seize the show
Well, this
cause.
is not the first time,
Kindly
lord.
seize the show cause.
Allegation there.
Well, previously also there was a caution against the headmistress, my lord. Board passed and
Caution was without jurisdiction because it was on basis of a teacher's complaint.
she was supplementary affidavit. In that affidavit, she relying upon that she never know about the suspension order or something. But after getting the suspension order, first of all,
Tell me what is the reason? What is the allegation against her?
the allegation is most of them she never come to school and not properly.
That is not the charge sheet.
And there
The
is
show
Sir,
cause.
please wait. Yes,
lots of allegation there, lots of teaching staff and not be misbehaving with the teaching and non-teaching staff.
misbehaving.
Yes.
That was a old allegation.
Let us have one complaint in that 200-page writ petition.
My lord, allegations and show cause. My lord, kindly look at the show cause.
Kindly
That
look,
should page
but the
165.
only allegation by the students was that the Bengali teacher does not attend school. Kindly see page 70.
And my lord,
Kindly see
and-
page 70.
and your lordship, proceeding initiated not only against the
It has
headmaster, the
become
other teacher, both the teachers who are fighting your lordship,
The petitioner
against
is,
both of them it has been initiated.
One thing, Lord.
is serving as the headmistress of a school. Stop. She is aggrieved with the action of the board in initiating disciplinary proceeding against her and putting her under suspension. Stop. Learned advocate representing the petitioner alleges that it was absolutely improper for the board to take steps in response to a complaint which has not been filed by any of the authority mentioned in Rule 5 within bracket 1 of the West Bengal Board of Secondary Education, bracket open, appointment, comma, confirmation, comma, conduct and discipline of teachers and non-teaching staff, bracket close, rules, comma, 2018. Stop. It has been submitted that the board is proceeding with a predetermined mind. Stop. The copy of the complaint relying on which the proceeding is initiated has not been served upon her.
Not required, your lordship.
Stop. Next. The learned advocate representing the board relies upon rule 5 within brackets 12 of the aforesaid rules, where the board has power to initiate suo motu disciplinary proceeding if there is reason to believe that any misconduct has been conducted by a teaching or non-teaching staff. Next. Learned advocate representing the school submits upon instruction that there are several allegations against the petitioner. The petitioner has also raised an issue with regard to the power to review the
Transfer orders.
order of transfer. Stop paragraph. It appears that the issues raised in the instant writ petition cannot be decided without granting an opportunity to the respondents to file their respective affidavits. Stop. The respondents are directed to file affidavit in opposition within a period of 4 weeks, reply if any within a fortnight thereafter. Stop. Liberty to mention the matter for hearing immediately on conclusion of the aforesaid time period. Stop. The report of the Inspector in charge, Rajarhat Police Station, Bidhannagar Police Commissionerate, dated 23rd February 2026, mentioning that the office chamber of the headmistress of the school has been sealed under proper memo of sealing is retained with the records.
May I indicate one thing, my lord, subject to your lordship's kind, my lord, correction, my lord. Lord, now the office chamber of the headmistress is sealed. Lord, school has to be, will not function.
No, an inventory is to be conducted as to what is there. Otherwise, somebody has to run the school.
But one thing, my lord,
Lord,
Inventory will be conducted.
one thing, my lord, one thing.
first inventory to be conducted, thereafter, my lord, my lord, this office of the headmaster or headmistress, it would remain open, my lord.
Will be?
Remain open, my lord.
Yes, yes, certainly.
One thing,
It cannot be
But
closed for
otherwise-
eternity.
Yes.
No, no, never.
my one thing, my lord.
Right?
Unless my lord stays the order of suspension, but I have, my lord, nowhere to go, neither here nor there.
Suspended.
But how could the
Suspension is
transfer
a
orders have been
punishment.
reviewed?
Suspension is not a punishment.
And this
by
is
the
a
government.
supplementary affidavit, my lord, which I have served. Some, my lord, pleadings which were not there, my lord.
My lord, kindly
Every party has been served.
indicate one thing, my lord, inventory would be done
Yes,
within
yes.
3 days. And
By the way.
DI would ensure that school
Right,
runs,
yeah.
my lord, smoothly.
The apprehension of the petitioner that the documents and cash lying within the office chamber of the headmistress may have been misused behind her back has been taken care of by the as the said chamber has been sealed in the presence of the representative of the petitioner. Stop. The
But DI would take
district inspector of schools is directed to engage a competent person under whom an inventory shall be conducted by opening the office chamber of the headmistress.
The representative of the petitioner will be there.
Yes. The representative of the petitioner, comma, the representative of the school
authorities. my lord.
and the one of the police officers of the Rajarat police station shall remain present at the time of conducting the inventory. Stop. The inventory list duly signed by the witnesses shall be
Furnished to all the,
supplied to all the parties. Stop. The headmistress's room shall thereafter be kept open for regular use.
lordship.
Stop. Next. The district inspector of schools shall ensure that
Smooth functioning of
the
the school.
day-to-day running of the school is not hampered in
Lordship.
any manner whatsoever.
But one thing, my lord.
The petitioner is directed to cooperate
Lordship, my lord.
at the time of conducting the inventory.
I have not been informed about who is the teacher in charge. To whom am I expected to hand over charge?
Not necessary, not necessarily required.
The DI
It
will
is
take
there in the
necessary
letter of
steps.
the.
Letter handover all to DI.
Yes.
Letter
And
handover
not,
has to be-
As the petitioner has been suspended from service and the suspension is under challenge, comma, the petitioner shall hand over charge
the DI.
to the district inspector of schools. Yes, sir.
But if necessary, in the office of the DI of schools, because there's been an attempt on a life once, there has
Police would be there, my lord.
police were there the other day also only to rescue her,
He would have. she
only
would
to
have-
somehow ensure that she comes out alive.
So present at the time of.
Not at the
sitting.
time of inventory, when the last incident occurred, my lord, in September 2020.
There was
The
a
police
total
had to be rescued. The petitioner had to be rescued by police and lady police. But so let her hand over charge in the office of the DI of schools.
He will go with the inventory. She will
Office
be
of the
present in
DI.
office.
Yes.
Somebody has to take it. Let the responsibility be fixed in the office where you will give, to whom you will
To the
give.
DI, my lord has indicated to the
Yeah.
DI.
At the
I have
school,
mentioned that to
Yes.
the DI.
At the time of
Then
inventory.
who will ensure her safety in the school? My learned friends.
Oh, you are not going to school. You
Then
are
where do I hand over charge?
To the DI,
Where?
in the office of the DI.
My lord indicates that, my
The
lord.
office of the district.
My lord
inspector of
indicates
schools.
that in the order.
Right.
14th, that 14th.
And my lord, at the last of all, my lord, I'm praying for stay so that I can take another chance in court number 11.
Stay for operation of this?
Yes, yes.
আচ্ছা আচ্ছা যেখানে বললাম না হ্যান্ড ওভার চার্জ টু দি ডিআই হ্যাঁ ইন দি অফিস অফ দি ডিস্ট্রিক্ট ইন্সপেক্টর অফ স্কুলস ডিআই থাকবে টু দ্য ডিআই ইন দি অফিস অফ দি ডিস্ট্রিক্ট ইন্সপেক্টর অফ স্কুলস ঠিক আছে আফটার দি অর্ডার ইজ ডিক্টেটেড ইন ওপেন কোর্ট কমা learned advocate for the petitioner prays for stay of operation of the order stop the prayer of the petitioner is considered and is hereby rejected.
My lord has recorded the supplementary affidavit has been filed.
And the supplementary affidavit filed on behalf of the petitioner in court today be retained with the records. The
And
copy of the same has already been handed over to the learned advocate representing the respondents.
that
Indicate the time, my lord, when she would hand over the charge, my lord, footage, my lord.
আচ্ছা hand over charge করলাম তো within 48 hours.
let the inventory
That's
take
right.
this weekend, my lord, so that an advocate can be present at the time
No,
of it.
weekend the teachers may be there. Saturday's opening is a day open for them for the
School is open.
school is open.
Yes.
School
Saturday, my lord, one advocate I can delegate to be present for this.
7 days from today, today is Monday.
Yes,
Yes.
Saturday.
Yes.
And you can do it within this time. The inventory you can
Yes,
do
yes,
it.
yes, yes, yes.
How he is for the board.
No, no, I'm
state.
No, he's for the state. He's not for the board.
Oh. Well,
Not it,
either here, not there.
The inventory shall be conducted by 28th of February 2026. By means any day. Acha, prior notice of inventory shall be served upon the petitioner and
All these
all
stakeholders.
other persons whose presence will be required at the time of conducting the inventory.
And let only the police make a video of this, not all the teachers, and post it live on Facebook. Let the police make an inventory video. Yes, the teachers indulge in Facebook live, my lord, posting videos from here. Let that exercise not be carried out.
I am not passing any order with regard to this. Item 70.
My lord has rejected that prayer for stay.
Yes. Cannot be. 77, did you intimate?
এই কথা ছিল যে স্কুল ডে টু ডে ফাংশনালিটি আমি ওই জন্য আমি অসুবিধা ছিল
Item 30,
kindly takes up the writ petition. Petitioner is, my lord, belonging to economically weaker section of the society. He had, my lord, rendered service. Kindly comes to page 17. This is, my lord, appointment under the noted such and such Manipur SV High School. Name is Shomiran Pandey, assistant teacher. Approved with effect from 27/4/2018 till 7/9/2018. Mode of selection, managing committee and such and such. Note beyond, the approval of the appointment is hereby accorded against short-term maternity leave vacancy in place of such and such at this school. So therefore against substantive post. Next page is, kindly takes note of the date. This is till 7th September 2018. Next page is serial number 2 is the petitioner before lordship. From the next day onwards, 8/9/2018.
Say from 27th of April 2018 till the 30th of June 2019, you
Yes.
were in continuous service.
Yes, short term.
Accordingly, at least 1 year service benefit to
Yes,
that
yes.
should be given.
It was given also. Kindly comes to,
Thereafter taken back.
yes, kindly comes
What
to
is
page
the
45.
stand of the commission in the
And of
report?
this commission in the reply is that it is being said in paragraph 3 of the reply of the report in the form of an affidavit. At the outset, it is stated that the instant writ petition is not maintainable in as much as the petitioner is not entitled to the marks on account of the teaching experience, since he does not have 1 year's service, which is mentioned in the application form. I'll come to the application form because I've mentioned the first school in the application form. The rules required at least 1 year of continuous service in quote unquote any government or government aided, government sponsored schools in substantive posts. They are trying to substantiate on any, as if the word is there in the rule. I'll draw your lordship's kind attention. They have also annexed the rule in that my lord, affidavit itself. Kindly comes to page 23 of that, my lord, report. There the rule, the relevant part is there. The rules do not contemplate any. The word any that they are trying to substantiate is not there in the rule. This contention of theirs is misconceived.
What type of a school is this? Manipur SV?
That is an aided school. Government aided school. Kindly sees, Malad, DI is giving the assistant additional district inspector of school is giving Malad the appointment.
Other one also?
Both.
Mangu Surya or something?
Yes.
This is also
Additional district inspector of schools is giving the appointment.
government.
State government.
Hmm.
State government substantive post, because I am being replaced in respect of a substantive teacher who is being going on first in respect of maternity leave, second in respect of short-term vacancy, place of such and such.
So I can understand the one is any government or government-aided school and fragmented service in two different schools.
Any word is not there in the rule.
All
That
right.
is erroneous. Kindly comes to the rules, page 23.
Now what does any mean over here?
Any, they are trying to say that you have to render substantive post in one school. It cannot be two schools. That is the contention that they are trying to substantiate. The service should be in one school, otherwise it is fragmented. Because in the application form, I have mentioned the first school because there is only place for mentioning the first school. And the logic is totally erroneous in view of the fact that say in respect of my lord full-time teachers, they have also been transferred to several schools. So they have mentioned the first school and after they taken
Transfer cannot be done within a year. You
Say-
have to have a minimum period for a transfer order to be
their
passed.
contention is
right?
the one school.
Yes.
But in respect of the other teachers also, where persons have been given 10 marks.
Show me. Show
No,
me,
that
please.
is not there, but that's the logic.
Rules.
Rules 23. Page 23 is the relevant part. That is also annexed in there. It's annexed in the writ petition also
23 of the.
of the report. Page 23.
All
Report
right.
that your lordship is holding. I am
Correct.
showing it from here itself.
Yes. At the government.
At the secondary level, in
Next.
a government or government aided or government sponsored school calculated on the basis of 2 marks for each year of service in the substantive post as permanent or contractual basis. Now kindly see from where the word any comes. Kindly takes up their form. That has been annexed in the affidavit and reply. Page 24.
Just interrupting my learned friend, let him proceed on the basis that it should have been read as A, not any.
I knew this will come. The moment he read that word, it came to my mind that this will be your stand.
It should have been, it is, if your lordship desires.
This is the reason I wanted to know where from what does this any mean.
Any is there in the form. It is in the form. Page 24 is the form. It is any. So my contention is that the logic that they are trying to substantiate that it has to be in any, then it is also in respect
How
of
do you-
permanent teachers.
Suppose any is not there. How do you get out of A?
But A would be, A in respect of would be that, say for instance, the A is there and a person is claiming 10 years of service, 10 marks for say 5 years, for 2 marks for each year. So in that case also, because the regular teachers have been transferred in several places, that is the logic that they are trying to substantiate, that you have to work in only one school for getting the marks for
No,
prior
that is
teaching
not the
experience.
logic.
So that will be the logic. If A is there, kindly see, if A is there, A will be for permanent as well as contractual. At secondary level, in a government or government aided or government sponsored school calculated on the basis of 2 marks of each year of service in substantive post, in a substantive post, permanent and contractual basis. So therefore, if a teacher, regular teacher is, they have been transferred to many places.
Not within 1 year.
Maybe here it doesn't say 1 year. It says it is in respect of entire place. Say for 10 years, kindly takes the example of 10 years. And this cannot be in any case fragmented because there is no fragment. It is one day I have been released from, this is the only case that is there. In all other contractual cases, my lord, there is fragmented cases where your lordship has been pleased to refuse also in one matter. But this is one of a matter. And now my lord kindly sees why I am before your lordship. Kindly sees my lord the writ petition again. My application form.
How much marks did you secure?
Yes, that is what I am trying to substantiate. First is page 45, my application form. Lordship may kindly takes up the writ petition.
Yes.
First is the application form. Kindly sees name of school in work is Manipur SV because this is the first school that I worked. If there is only one school that I can give. Next is kindly comes to page 48. This is the provisional panel. Here my name is not there. Kindly comes to the marks obtained by the last candidate. Page 51. 78.50. Now kindly comes to the next page. My name is appearing at serial number 7. Lordship is there?
77.75.
Yes. Now kindly calculates
58.
52 plus 10 and 15 is 77. They have not taken into account plus 2. They have said plus 2, that 2 marks that they have not added. If this 2 marks is added, it comes to 79.75. Lordship may kindly adds 52 plus 10 plus 15.75 is equal to 77.75. They have not calculated 2 marks. Which
So
they say,
experience score, it says 0.
no, 2. Page 52, Lordship is.
Page 54.
No, 54 thereafter they have altered it. 52 they have given me experience score. Kindly see page 52.
See,
Page 52.
calculation remains the same. It is 77.75.
Yes, that is the error. That they were also of the view that I am entitled to. Subsequently, they have suddenly changed and my lord altered.
Your position, your total marks did not alter, but the
No,
2 marks
if
admittedly
2 marks
is
is
not there.
taken, if 2 marks is taken, I come to 79.75. I easily go beyond 78.5 such and such.
Yes.
This is the only my lord, these
Commission.
kinds of cases will not come. A person will get the job, my lord.
1
He's
minute.
a fresh candidate, economically weaker section of the society.
This is our explanation, paragraph 6. Paragraph 3 is first.
Yes, 3 has been placed.
It is stated, paragraph 6, page 4. It is stated that as per rule such and such of the schedule 2, prior teaching experience of a candidate carries 10 marks. The rules provide that any candidate who has experience of teaching at secondary level in a government aided or government sponsored school calculated on the basis of 2 marks for each year of service in a substantive post as a permanent or contractual. Thus, there is evidence that for availing marks for teaching experience, candidate should have rendered service in a substantive teaching post at the secondary level in a government aided either as a permanent or contract. Any candidate who did not render at least 1 year of service as either permanent or contractual will not be eligible. While the rules do not explicitly define.
Is it your case that the petitioner has not served in a substantive post?
It is
Yes.
assumed not substantive.
The
Deputation
petitioner-
secretary, I was inquiring from him.
Substantive post.
DIS.
And the petitioner is a contractual employee for a particular period. But fact remains this period is continuous.
But 2 different posts, 2 different schools, 2 different engagements, 2 different approvals.
It doesn't matter. You want to see whether the candidate is in service for 1 year or not.
With respect, there is admittedly, in our application form, experience has to be indicated reading it together with the rules in a school, together with the application form.
Did your application form have any option for putting in names of more than one school? You do not. What can the candidate do?
Kindly pardons me. If your lordship kindly read a little down of the affidavit, paragraph 10.
Yes.
27th April to 7th September 2018 was her engagement in one of the schools. And in the next school, 8th September to 30th June. It's another school, again on deputation. What is falling from your lordship that this is totally continuous.
Had there been a break?
Even 1 day's break, the matter would have been different.
Yes.
The fact remains, 1 year continuation in either of the schools was not there. 1 year.
Maybe you want 1 year. Whether in
One
one
year in
school,
a substantive post.
she's
Here,
there.
Substantive posts are not there.
See, that way, if you go on, then I can remember arguments made with regard to some prior teaching experience where the singular number and plural digits and all these things comes in. Had there been a day's break, it would have been different. Since the service is continuous and for a period of 1 year,
One thing is, he was not below the cutoff. That is one aspect of the matter.
had 2 marks been given.
After deduction of 2 marks also, he is not below the cutoff. So therefore, he must He is in the wait list.
Yes, I am in the
This makes a lot of difference.
Your lordship holds. Your lordship holds. And I am kindly records our submission that this is our submission. Thereafter, I leave it to the court. Let the court decide. If the commission feels, the commission may go anywhere. But what your lordship is saying, is not is correct. Correct position factually also. Legally also, that is the
Report in the form of affidavit on behalf of the commission and the exception thereto filed by the petitioner in court to be detailed with the records. Stop. The petitioner participated in second SLST 2025. Stop. His name features in the list of waitlisted candidates. Stop. He is aggrieved as marks on account of prior teaching experience have not been awarded to him. Stop. The petitioner has annexed documents in support of the submission that he was engaged in government aided schools.
Only one. There are other matters where your lordship is examining as to why 2 marks was given and 2 marks was there initially, and that we have explained. There was no. In this case, your lordship is allowing regarding this
Continuous.
Nothing else. Because the 2 marks we have not given. Even if we have erroneously given it to someone, we have deducted it in the final.
All right. I'm not going to that. That I'm not touching.
The lordship only holds that it's a continuous service, so therefore it's entitled.
Absolutely. That I'm not touching. Because I know that issue is pending.
Great.
Acha. Ki bolam? For the period from 27th April 2018 to 7th September 2018, and again from 8th September 2018 to 30th of June 2019. Stop. The appointment was made by the Additional District Inspector of Schools, Secondary Education, Shodor Subdivision, Purulia. Stop. Learned advocate for the petitioner contends that as the petitioner was in continuous service for more than a year, marks on account of prior teaching experience for 1 year ought to be awarded to the petitioner. Stop. Paragraph. Prayer has been made to direct the commission to recalculate the marks of the petitioner upon adding 2 marks on account of prior teaching experience. Stop. The aforesaid submission and prayer of the petitioner is opposed by the commission. Stop. In the report filed by the commission, the stand taken is that the petitioner has not worked for a period of 1 year in any single school. Stop. He has fragmented service in 2 different schools, contrary to his disclosure in his application form. Stop. Submission is that a candidate who has experience of teaching at secondary level in a government aided or government sponsored school, calculated on the basis of 2 marks for each year of service, shall be awarded marks for prior teaching experience. Stop. Paragraph. The primary contention of the commission is that as the petitioner did not work in a particular school for a continuous period of 1 year, no marks can be awarded on account of prior teaching experience to him. Stop. Paragraph. I have heard the submission made on behalf of both the parties. Stop. The rules relying on which marks on prior teaching experience is awarded mentions that the candidate has to work at the secondary level in a government or government aided or government sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post, either permanent or on contractual basis. Stop. The petitioner admittedly served in a government aided school on deputation. Stop. The appointment letters of the petitioner were issued by the government authority. Stop. The service of the petitioner may have been in 2 separate schools, but there is no break in his service period. Stop. His first tenure was from 27th April 2018 to 7th September 2018, and thereafter from 8th September 2018 to 30th of June 2019. Stop. The same implies that the petitioner was in continuous service for a period of more than a year. Stop. The rules relied upon by the commission does not particularly mention about the service being rendered by the candidate in only one school. Stop. Had there been even a day's break in between the two appointments, then the stand of the commission that the petitioner was in fragmented service could have been considered. Stop. In the instant case, it is evident that the petitioner was in continuous service for more than a year, but in two different schools. Stop. The stand of the commission in not awarding marks to the petitioner on account of prior teaching experience cannot be accepted by the court. Stop. Next. In view of the above, the instant writ petition stands disposed of, directing the commission to consider the prior teaching experience of the petitioner from his initial date of appointment on 27th April 2018 to his last date of engagement, that is 30th of June 2019, and award marks on account of prior teaching experience. Stop. The total marks obtained by the petitioner shall be recalculated accordingly upon awarding marks to the petitioner on account of prior teaching experience. Writ petition disposed.
Once service has been approved by the DI, not government approved.
Approved by the
Approved by the DI.
approved by the district inspector of schools.
Grateful.
In any case, my lord, in other cases where they will come up saying fragmented service, the word continuous is not there in the rule. Even if there is a fact
এটা তো তুই পেয়েছিস,
না এটা পেয়েছি পরে মামলা তো অতগুলো
Let
হচ্ছে
fresh arguments be made and we will think it
Yes,
afresh all over again.
totally on the basis of facts and circumstances of it.
All right.
Great.
Deeply obliged, my lord.